So I don't think that it is a matter of dispute any longer that there is a causal relationship between the rule of law and economic progress and development in any society. A most cursory glance around the world, identifying vibrant economies, identifying countries where economic progress is booming, one would find side by side a society where the rule of law is respected and that rule of law has as a fundamental pillar of its structure a functioning, efficient, and competent legal system. A legal system that commands the respect of all the citizenry, including, of course, the business community. A legal system that is impartial and a legal system that enjoys the confidence of the ordinary man as well as the investor. That is a given any part of the world. And economists in recent times have made that connection very emphatic in various writings. In the words of Nobel laureate Professor Douglas C. North, he says this: long-term economic growth entails the development of the rule of law. More recently, Francis Neat, immediate past president of the International Bar Association, observed that the rule of law increasingly has a new and eminently powerful advocate in big businesses, which is realizing that in a country without it, doing deals can be very difficult. And I also want to share a quotation from Lee Kuan Yew, the former Prime Minister of Singapore. He says this: our reputation for the rule of law has been and is a valuable economic asset, part of our capital, although an intangible one. It has brought to Singapore good returns from MNCs, the OHQs, the banks, the financial institutions, and the flood of capital to buy up properties in Singapore. A country that has no rule of law, where the government acts capriciously, is not a country wealthy men from other countries would sink money in real estate. Now, those are sentiments that are very simply expressed, but they are deep and profound, and they reflect the realities of many societies across the globe. Of course, the situation here was in Singapore. So I don't think that we should spend much time in debating the vital and fundamental connection between the rule of law in a society and economic progress. They go hand in hand. If you look at the converse, wherever there is economic stagnation, wherever there is suffering, wherever there is economic deprivation, wherever there is sloth in economic growth and progress, you look in that society and you will see a legal system that is not functioning in the manner that it should. You will see a society where the rule of law is on the decline and does not obtain that paramount place in the structure of that state. And that is a truism which I don't believe we should spend much time in disputing. Now, it is important also that we understand what the rule of law means, because the rule of law has been with us as a concept from the beginning of time. And As society has evolved over the centuries, the rule of law itself as a concept has undergone changes. And for example, what was considered the rule of law 500 years ago or 1200 years ago is not the rule of law now, because society has evolved and concepts such as the rule of law have expanded, have evolved to meet the exigencies and the vicissitudes of a changing, dynamic, and developing society. It is common ground that we have inherited our legal system from Great Britain due to our historical evolution from colonialism to independence. Therefore, our legal system is tremendously influenced by what existed in Britain, and even now what exists in Britain, because case law authorities emanating out of the courts of England continue to be high persuasive authorities here to guide our judges in decision making. The textbooks that are published in England in relation to the laws of England are the texts that we are largely using in Guyana and the Caribbean, because we have inherited that legal system. So if you want to go and find out what the rule of law is, for example, England is a good way to start. And in whatever obtains rather as the rule of law in England is what will obtain in Guyana, maybe with some modifications, but largely will be what is the rule of law in Guyana. The latest and perhaps the most uh, comprehensive assessment of the concept of the rule of law was done in 2011 by Lord Bingham, a former Lord Chancellor of the United Kingdom. He wrote a book, and the title of the book is The Rule of Law. And he examined the evolution of the concept. The rule of law, when the concept was first formed, all it meant was everyone is equal before the law. And that and so that no one should enjoy any special or preferential treatment in the eyes of the law. And that is why if you look at the statute of Lady Justice, you see the statute blindfolded. That is an embodiment of what the rule of law was at that point in time. That justice sees no one. You can be a multimillionaire, you can be Exxon Mobil, or you can be the man on the 44 minibus, the ordinary Guyanese. When you appear before the courts, when you appear before the justice system, you are guaranteed equality. You are guaranteed equal treatment of the law. And that is represented by the Lady Justice not recognizing, not being able to recognize the identity of the litigant. And that is reflected by the blindfolding. But as I said, it has evolved very much beyond that. And Lord Bingham, in his work, lists 8 principles as principles that form that consortium called the rule of law. And the first one is that the law must be accessible and, so far as possible, intelligible, clear, and predictable. I repeat for emphasis, the law must be accessible and, so far as possible, intelligible, clear, and predictable. So every state has a duty to ensure that its laws are accessible. That's the first thing. The ordinary citizen must not endure an ordeal in accessing the law. And that is why in 2012, under my stewardship as Attorney General, the then government of Guyana had completed a revision exercise of the law. And revision exercise of the law meaning that you look at all the amendments that are out there and you put them back into the laws, into the volumes of the laws where they are supposed to be. The last such exercise was done in 1978, 2 decades or more prior. So to get the laws in one central place, one had to go through a tremendous and Herculean task of assembling together all the pieces of amendments and all the new laws that would have been passed since 1978 and consolidate them to form one laws of Guyana. And that is why the project, which was done by Justice Claudette, well, she headed the project, Justice Claudette Singh, took a number of years before it was completed under my stewardship. It started under the stewardship of my predecessors, Dudnath Singh, Senior Counsel, and Charles Ramson, Senior Counsel, and it was concluded under me. That was so because of the volume of work that had to have been done. And right now, we are at 2012. That if you look at the purple volumes of the laws of Guyana, it ends at 2012. So from 2012 to 2020, we now have 8 years, again, of scattered pieces of legislation all over the place. If you recall, in many of the judgments during that election, that horrible election saga of the 5 months post the March 2nd elections, when there were a series of litigation, many times the judges had to complain that the law is in such a disorderly state because we had difficulty finding the various pieces of laws dealing with registration, house-to-house registration, continuous cycle of registration, because they were passed in this piecemeal manner, and some of them collided with each other. Some were overtaken by events. So while a tremendous amount of work was done, there is still a great amount of work to be done to make the law accessible once again in a wholesome and efficient way. The other component of the principle is that it says that the law must also be intelligible, clear, and predictable. It means that the language in which the law is expressed must be intelligible and must be clear. Now that is another fundamental hurdle that the layman, the ordinary person, faces when attempting to read the laws. But there has been a movement worldwide to move away from that style of drafting. And now you have a new concept developed in countries like Canada and Australia, where they do legal drafting in plain English. And that is how we are now being educated. Zulfi, you are at law school now. You will be doing legal drafting, and there's a book, and the name of the book is called Legal Drafting in Plain English. So we are moving away from that kind of complex, archaic, pedantic, and sometimes ambiguous type of language normally associated historically with legislation. And you would find now that the modern statutes are being drawn or drafted in language that is far more clear or clearer than their predecessors. And the other component of this first principle is that the law must be predictable. What that means is that the law must be applied in a predictable way. So that when a decision, for example, is made in relation to a particular factual matrix and the law is applied to that factual matrix, if there are similar facts that present themselves, one would expect that the law is applied to get the same results that similar factual matrix produced, so that there is predictability in the law. Judges are expected to rule based upon precedent, based upon uniformity. That's why today, for example, we were arguing that for 300 years, in relation to an elections petition, late service of an election petition, late service is fatal to the petition. It deprives the court of jurisdiction to hear the petition. Now, one would expect that the court would follow and would not depart from 300 years of consistent jurisprudence. That is what is meant when they say that the law must be predictable. The second component that Lord Bingham dealt with is questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. So they're saying here that once legal rights are involved and liabilities are involved, then the medium by which disputes arising in relation thereto should be resolved is not by the whim, caprice, and opinion of administrators or policymakers or politicians, but it must be determined in accordance with principles of law. So whether a man is entitled or a company is entitled to get a particular license that that company has applied for, sometimes you see the law says that the license will be granted upon such grounds as the minister deems fit. Now, politicians run away with the idea that because the language appears so loose and the language seems to reside in discretion in the minister can decide by himself and based upon his own unique discretion whether or not that license should be granted. The law says, no. No matter how the statute is crafted, no matter how untrammeled a discretion may appear on its face, all discretions must be exercised in accordance with law. What that means, the grantor of the license in question must only take into account relevant considerations. He must discount irrelevant considerations. He must always act in good faith. If possible, he must hear the person who is likely to be affected by his decision. And principle, he must always act reasonable. What that means, he must act in a manner that a reasonable person vested with that power would have exercised that power. And he is not entitled to exercise that power unreasonably. And he is not to discriminate on any ground whatsoever in the grant of that license. So a man should not be refused a license because the color of his hair is red. One must look at the policy of the act, the purpose of the license, and the qualificatory factors that one must satisfy before one qualifies for that license. And the license should be granted on those bases only and not upon the peculiar discretion of the minister, though the language of the law may suggest that. The third issue is the laws of the land should apply equally to all, save to the extent that objective differences justify differentiation. Now, this was the original concept out of which the rule of law evolved, as I explained at the commencement of this presentation, that the law should always be applied equally, save and except where the situation requires different persons to be treated differently, and persons and the factors that would qualify different treatment must be known to all, and these persons must qualify to be the recipient of that special treatment or different treatment, whatever it is. Other than that, the law must be applied equally. For example, look at our Constitution. Our Constitution outlaws discrimination on almost every ground. On the ground of race, on the ground of class, on the ground of religion, on the ground of ethnicity, on the ground of culture, on the ground of gender, on the ground of sex. All these things you can take into account and discriminate against a person on these grounds. Yet, in the very Constitution, it allows for discriminatory treatment positively in favor of Amerindians, because Amerindians have they are recognized as a peculiar segment of our society, who requires special treatment. So our Constitution permits positive discrimination in favor of the Amerindians. The fourth component of the rule of law is ministers and public officers at all levels must exercise the powers conferred upon them in good faith, fairly, and for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. Remember, I spoke about this a little earlier. Once ministers are granted a power, or any public officer for that matter, they are to act reasonably, they are to act in good faith, they are to act fairly, and they are not to exceed their powers. In other words, we had a situation recently where ExxonMobil, for example, got a license or a permission under the EPA Act, the Environmental Protection Act, for 20 years under the previous administration. Whereas the Environmental Protection Act itself limits the life of an environmental license to only 5 years. As a result, I advised the EPA I entered into an arrangement with ExxonMobil for the license to be adjusted from 20 years to 5 years when someone filed a litigation. Because clearly, the regulatory power there, the EPA, exceeded their mandate. That grant of a license in excess of 5 years would have been ultra vires the power of the grantor of that license, because the law limited that license to 5 years. Next one is that the law must afford adequate protection of fundamental rights. Now, no investment has any value in any society if that society does not recognize the basic human rights of its people or any people. One of those rights is the protection of private property. Investments, as you know, consist of property. If you have a society that doesn't respect that right to protect private property, then you will not get investments. And that's a fundamental tenet of the rule of law. Human rights must be protected by the state. And when I say the state, I mean the state in all its apparatus, all its agencies, through the government organizations, all public authorities, all public officers, the judiciary, the parliament, everyone in the state, all institutions are bound to respect and protect fundamental human rights. And fundamental human rights, as I said, right to property is one, right to life is another, right to freedom of the press, freedom of expression, right to movement, right to liberty, right to have a criminal case tried or a civil case tried before a fair and impartial tribunal, the right to be protected against discrimination, the right to be protected against cruel and inhuman treatment, the right to be able to practice your religious and cultural pursuits of your choice. All these are fundamental rights. And any society that wants to progress well economically must have the wherewithal to protect and enshrine these rights and protect them in a real way so that private investments and people are protected in the country. The sixth one is means must be provided for resolving without prohibitive cost or inordinate delay bona fide disputes which parties themselves are unable to resolve. Now, this is a big one. This is where the state has a responsibility to ensure that there is an institution in place that allows for the fair, just, and competent and efficient settlement of dispute. That responsibility the state normally entrusts to an institution called the judiciary. And that is why you have so many protective mechanisms protecting the judiciary. For example, all judges' salaries are paid as a direct charge from the consolidated fund. And a judge's salary or a judge remuneration package can never suffer a diminution. Judges' salary cannot be adversely affected in any form or fashion. That's part of their security of tenure. Then judges can only be removed from office on certain grounds. And the grounds are one, misbehavior, and two, incapacity arising out of an infirmity of body or mind. You can't dismiss a judge on any other ground. That gives that judge security of tenure until he's ready to retire, and the retirement is fixed by law in the Constitution, the most supreme law. The ages of retirement are fixed for judges in a different part of the judicial system. Court of Appeal has a different age retirement. High Court has a different age retirement. The position of Chancellor has a different age requirement. Also, the process by which judges are appointed are protected by the Constitution, and only that mechanism established by the Constitution can be employed for the appointment of a judge. A process has to be concluded. The politicians merely have basically a ceremonial role, except for the appointment of the Chancellor and the Chief Justice, which require an agreement between the two politicians. And unfortunately, since we changed our constitution in that regard, we have never had that agreement. And that's something that we have to relook at some point in time in the near future. It makes no sense have a mechanism there with the best of intentions and it is not working. It's better you didn't have it. So all these mechanisms that I've referred to guarantee to the judiciary and guarantees to the public independence of the judiciary. And that independence, at least in theory, demands or assures that judges will not be intimidated when they give a decision, neither by politician, nor big commercial interest, nor by the ordinary man, that no one can touch them because of their decisions. And that assures guarantee, that assures independence, that assures that the system will deliver justice. But there's only one component of the system. The decisions also must be fair. And what is fair? Fair must be in accordance with law. It must be in accordance with the fundamental tenets of justice. You can't have a decision that is repugnant to canons of justice that will shock one's sense of fairness. For example, 33 being a majority of not being a majority of 65. That's an outstanding example that I can point to. So, you have to have decisions, quite apart from an independent judiciary. The decisions that come must accord not only with principles of law, but with the ordinary man's sense of fairness and justice. That's fundamental. And also, the system must work in an efficient way. and meaning that decisions must be delivered in a timely manner. Decisions must be delivered in a timely manner so that you can have early resolution of disputes. Now, we in Guyana have had this backlog situation for quite a while, and various initiatives have been employed. And I'm pleased to report that they have worked, and we have basically largely eliminated the backlog. But it was not an easy task. You had various initiatives had to have been employed. Judges were paid specially and separately to deal with backlogs. Judges were paid to work overtime. Um, New rules were brought into to place. Specialized courts were created. Alternative dispute resolutions were explored. And, and all these culminate in, I dare say, and I must say, to the credit of the judiciary, improved efficiency now being enjoyed. And you see it right now before your eyes. Today, we started to hear an elections petition filed a few 2 months ago. In 2015, we filed an elections petition that is still in the system, never heard up to now. I give you that example, a live example that will resonate with the people and will resonate with your viewers to show you how the system is working. And that has to do with all the improvements that have been made. But the point I'm making, however, that you must have that mechanism as part and parcel of the rule of law so that you can get a foreign investment. No foreigner will invest in a society where his property will become insecure, where the government doesn't respect private property, where there is the ministers misbehave, they don't follow the laws, they make decisions that are arbitrary, capricious, and unreasonable, that, the society doesn't protect the investment, so government can compulsory acquire an investment like the Berbice Bridge in one swipe. That doesn't augur well for investors and investors' confidence in an economy. That shows a society where the government of the day is prone to acquire private property, to appropriate or expropriate. These are concepts that are repulsive to development. They are repulsive to one's sense of justice. And also, you also have to have alternative procedures to the judiciary. So that's why right now the Attorney General Office is working on a new dispensation to deal with mediation. If you examine many of the contracts of the oil companies and the new companies that are coming into the country, there is an arbitration clause. Once that is there, then the law says that one is bound to go to arbitration and ventilate the dispute through arbitration. But when you examine our arbitration current structure, it's about over 5 or 6 decades old. It's clearly archaic, clearly anachronistic, and can't meet the demands of a new and dynamic industry or industries or commercial world, if you wish. So right now we are examining the arbitration architecture to make it modern. And there is a model legislation promulgated in the world. We are in the process of adjusting it to meet Guyana's expectation, and also to link it to the judiciary, while at the same time having arbitration as a process available to the parties outside of the legal system if it doesn't wish to go into the formal legal system. So you'll have a hybrid arbitration system, one that is integrated and forms part of the judicial process, and one that is wholly independent of the judicial process. As I said, the contracts now, they say that if there is a dispute between the parties, including the government of Guyana, they have to go to Brussels or London or New York or Texas to resolve these disputes. we can resolve them right here by arbitration. Once we put the requisite mechanism in place and the statutory framework in place that is modern and responsive as those in the destinations chosen by these contracts. The seventh one is adjudicative procedures provided by the state should be fair. Well, I've dealt with that already. That is caught up, that's covered by the previous one. And the last one is the rule of law requires compliance by the state with its obligations in international as in national law. And Zulfi, this brings me to the question that you raised at the beginning. The obligation of the state to obey the law and obey its international obligations. And we saw in recent past a government of the day that trampled upon its own constitution repeatedly, violating it all the way, instructing the Public Service Commission not to promote public servants, President instructing the Police Service Commission not to promote police officers. All are all in violation of the law, because these are institutions within the constitutional structure that guarantees protection to certain classes of employees to make them insulated from the political caprice and whim and fancy and abuse of politicians. You have the chairman of GCOM being appointed clearly in violation of the Constitution. And of course, you saw the 5 months of madness where the Constitution was turned upside down. The rule of law was turned upside down not by the investor, not by the private citizens, but by the government of the day. They were leading the charge. That cannot obtain in a society that wants the rule of law to obtain. That cannot obtain in a society that wants to enjoy investments from major investments from all parts of the world. So I have outlined there the various tenets and components of the concept called the rule of law. And these are the concepts and components and ingredients that we have to assiduously work towards implementing, improving, making more efficient, making more functional, making more competent. And once we do, and we are doing that, we are in the process of doing that. And the more progress we make, I dare say, the return that we will get with the influx of investment will be commensurate and proportionate. Once we get the rule of law functioning at its optimum, we will get investments at its optimum. And that is the story of investments all over the world and its relationship with the rule of law. So no one, as I said, can second guess the importance of the rule of law and the importance and the relationship that it bears, the causal nexus that it has between that exists between investments and the rule of law. They go hand in hand, and that is replicated by examples worldwide. You choose the country, and I will tell you, you choose the country that has the most investments, and you look at the legal system, and you will see. Look at the quality of the judiciary, you will see. Look at the behavior of the government, you will see. Look at the way that the state machinery is functioning, you will see. And all of the concepts I have outlined there. So, with your kind permission, I will stop there and allow for the engagement to continue. And of course, I'm available for any questions which you may wish to pose or any of your viewers may wish to pose to me. Thank you very much.